So back in August, there was this case where a federal judge in Kansas ruled that fully automatic rifles are protected by the Constitution. But a month after that, another federal judge, this time in Hawaii, declared that they are not protected. What gives? In this video, we'll talk about two groundbreaking cases that have put the spotlight on automatic and short-barreled rifles. See what the hell is wrong with these federal judges. We'll dive into what their conflicting rulings mean for us legal gun owners, which federal laws are involved, and how we deal with this. We'll explore how these cases could impact the future of the Second Amendment and the types of firearms that may or may not be protected. Stay tuned for the full breakdown. In Kansas, Tamuri Morgan found himself in the crosshairs of federal law enforcement. He was indicted on charges of possessing a machine gun and a Glock switch, a device that converts a semi-automatic firearm into a fully automatic one. These items are heavily regulated under federal law, specifically the National Firearms Act and the Gun Control Act. What were the charges? Well, Morgan faced 2 counts under Section 922, subsection O of Title 18 of the U.S. Code, which is commonly known as illegal possession of machine guns manufactured after 1986. The government argued that both the machine gun and the conversion device fell squarely within this prohibition. As the case progressed, Morgan's defense took a bold stance, challenging the constitutionality of the charges. They argued that the Second Amendment protects the right to possess such firearms and devices, citing recent Supreme Court decisions that emphasize historical context in interpreting gun rights. A U.S. District Judge by the name of John W. Brooms presided over the case. In a decision that sent shockwaves through legal circles, Judge Brooms dismissed the charges against Morgan. He concluded that the government failed to demonstrate that prohibiting the possession of machine guns and conversion devices aligns with the nation's historical tradition of firearm regulation. Judge Brooms leaned heavily on the Supreme Court's decision in New York State Rifle and Pistol Association, Inc. Das diese Bleich, die Aussehen White Dosi Wohlige Bruin, which in a nutshell emphasizes that modern firearm regulations must be consistent with the nation's historical tradition of gun control. He noted that during the founding era, there were no laws prohibiting the possession of firearms based on their firing capabilities. Therefore, he argued, modern bans on machine guns lack historical precedent, which is a reasonable argument, especially compared to ruling in the next case. We'll talk about United States versus Chanamore Christopher Chan. A resident of Hawaii found himself under the scrutiny of law enforcement during a welfare check. In the trunk of his vehicle, officers discovered a short-barreled rifle modified to fire automatically, a combination that raised more than a few eyebrows. Chan was promptly arrested and charged with possession of an unregistered short-barreled rifle and a machine gun, both violations under the National Firearms Act. Chan didn't back down and argued that his Second Amendment rights protected his possession of these firearms, drawing from the Supreme Court's decision in District of Columbia v. Heller, which affirmed an individual's right to possess firearms for lawful purposes. Chan contended that his weapons fell under this protection. Presiding over the case, U.S. District Judge Derek K. Watson delivered a ruling that would ignite discussions nationwide. Judge Watson concluded that short-barreled rifles and fully automatic weapons are not protected by the Second Amendment. He referenced the Supreme Court's decision in United States v. Henry, which upheld restrictions on certain types of firearms, to support his conclusion. Judge Watson emphasized that these weapons are dangerous and unusual, and not typically possessed by law-abiding citizens for lawful purposes. This ruling stood in stark contrast to that decision by Judge John W. Brooms, who again ruled in that fully automatic firearms and conversion devices are bearable arms under the Second Amendment, protected by the Constitution. The Second Amendment might be short, but it's powerful. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This little line from 1791 has stirred up more arguments than a high-stakes poker game. and for good reason. In the early days of the Republic, the right was seen as a collective one, tied to state militias. But in 2008, the Supreme Court threw a curveball with District of Columbia v. Heller, ruling that the Second Amendment guarantees an individual's right to keep firearms at home for self-defense. No militia required. Fast forward to today, and things get trickier. Fully automatic rifles and short-barreled shotguns were unimaginable back in 1791, leaving courts to argue whether they're in or out of bounds. Anti-gun judges and lawmakers argue that federal regulations like the NFA and GCA are necessary for public safety. They claim that certain firearms, like fully automatic rifles, short-barreled shotguns, and even suppressors, are just too dangerous for regular citizens. To them, these aren't protected under the Second Amendment, which is conveniently twisted to fit their idea of reasonable restrictions. Under the NFA, citizens can only possess certain firearms if they're willing to jump through costly and bureaucratic hoops. Imagine you're interested in owning a short-barreled rifle, a suppressor, or maybe even a fully automatic firearm. Well, the National Firearms Act of 1934 means that you'll need to submit an application to the federal government, pay a hefty $200 tax, go through extensive background checks, and wait, often for months on end. And that's only if they approve you. It might not seem huge today, but back in 1934, that tax was essentially designed to price Americans out of access to these types of firearms. The message was clear. Only those with time, money, and patience could exercise their right to own these firearms. The NFA didn't stop at suppressors and short-barreled rifles. It clamped down on destructive devices, things like grenades and other explosives, labeling them under the same umbrella. But for the rest of us looking to own more standard firearms with certain modifications, the NFA restrictions made it almost impossible without government oversight, financial burden, and long delays. What started as a targeted law against gangsters in the 1930s evolved into a sweeping tool to keep everyday Americans from accessing specific types of firearms using the same weapon every restrictive law uses: bureaucracy. The Gun Control Act of 1968 took things a step further. While the NFA focused on specific firearm types and accessories, the GCA aimed to restrict who could buy guns at all. It barred felons, certain individuals with mental health issues, and those with specific criminal backgrounds from purchasing firearms. In theory, that sounds fine to some, but here's the kicker. The GCA also made it illegal to buy firearms through private sales across state lines, without going through a licensed dealer, adding layers of regulation to what should be a simple right. The GCA also laid the groundwork for modern background checks, establishing a foundation that lawmakers would expand in later decades. What began as a reaction to violence and assassinations in the 1960s, think JFK and Martin Luther King Jr., turned into a system ripe for overreach. Today, background checks and cross-state sale restrictions are often weaponized in attempts to build on the GCA and tighten the grip on Americans' access to firearms. With each new restriction, we're getting further from what the Second Amendment was intended to protect. In the big picture, the NFA and GCA have set dangerous precedents. These laws didn't just introduce new regulations, they introduced something far more dangerous. They gave the government power to negate that part of the Second Amendment that is as clear as day: shall not be infringed. As a result, the government gets to limit the types of firearms Americans can own and decide who gets to have access. There's nothing in the Second Amendment about only if you pass a background check or only if you can pay the tax. But between the hoops of the NFA and the walls of the GCA, our right to bear arms has been fenced in and fenced off. And as every new regulation stacks on top, it chips away at the core freedom the Founder Fathers intended: a fully empowered citizenry, armed and ready to protect itself without government interference. But all is not yet lost. In June 2022, the Supreme Court delivered a landmark decision in New York State Rifle and Pistol Association, Inc. v. Bruin, reshaping the landscape of Second Amendment jurisprudence. The court struck down New York's stringent concealed carry law, which required applicants to demonstrate a special need for self-defense to obtain a license. Justice Clarence Thomas, writing for the majority, emphasized that the Second Amendment protects an individual's right to carry a handgun for self-defense outside the home. He asserted that any firearm regulation must be consistent with the nation's historical tradition of firearm regulation. This decision set a new standard for evaluating gun laws, compelling lower courts to scrutinize modern regulations through the lens of historical precedent. Enter United States v. Morgan, where the federal judge applied the Bruin framework, examining whether the prohibition of such firearms aligned with historical traditions, arguing that the government failed to demonstrate a historical basis for banning these weapons, and ultimately ruling that they are protected under the Second Amendment. This ruling ignited a legal debate as it directly conflicted with other federal court decisions upholding restrictions on automatic weapons. The Bruin decision's emphasis on historical context has led to divergent interpretations among lower courts, highlighting the complexities of applying 18th century principles to modern firearms. That federal judge who ruled in favor of Tamori Morgan leaned heavily on the Supreme Court's decision in New York State Rifle and Pistol Association, Inc. v. Bruin, which emphasized that firearm regulations must align with the nation's historical traditions. He argued that during the founding era, there were no laws prohibiting the possession of firearms based on their firing capabilities. Therefore, modern bans on machine guns lack historical precedent. But anti-gunners who hate Judge Broom's decision argue that fully automatic weapons are quote-unquote weapons of war and not intended for civilian use. They contend that the Second Amendment was never meant to protect such firearms, as they are designed for military purposes and pose significant risks to public safety. The whole weapons of war argument is stupid when you consider what the Founding Fathers actually wrote. Back in 1791, everyone had the same tools. The musket was as much a weapon of war as it was a tool for self-defense, hunting, and yes, safeguarding freedom. If they wanted to stop civilians from having military-grade gear, they could have thrown in a "no muskets for the people" clause. But guess what? They didn't. When the Second Amendment was penned, the founders weren't thinking about gun types. They were thinking about balance. They knew that the people needed to be on equal footing with any force that might come knocking. The Second Amendment wasn't about some cozy right to hunt. It was about ensuring Americans weren't left outgunned and powerless against a tyrannical government. Fast forward to today, and it's the same concept, just with updated hardware. Modern firearms are simply today's version of the musket, the tools that keep citizens on par with any threat, foreign or domestic. Take those away, and the government is not protecting the people. It's disarming them. And that's all the time we have for today. We've covered the dueling rulings on automatic and short-barreled rifles from Kansas and Hawaii, where two federal judges couldn't be more at odds. We've also broken down how the National Firearms Act and Gun Control Act complicate Second Amendment freedoms, creating barriers and restrictions that distance us from the framers' original intent. And through it all, the Bruin decision has shone a light on the importance of historical context, reminding us that today's weapons of war argument ignores the founders' intent for an armed and balanced citizenry. But what's your take on that federal judge's ruling in the U.S. versus Chan case? Drop your thoughts in the comments. If you enjoyed this content, please hit like, share, subscribe, and don't forget to click the bell for updates on our right to bear arms.